Well, good afternoon, and welcome to our second session, our panel discussion. And I'd like to introduce our panelists, who you should be seeing on the screen. We are very pleased to have all three gentlemen with us this afternoon, and having them give graciously of their time in an effort to dig deeper into the IHRA definition and what it means and how it's used. I'm not sure where he is on your screen, but on the lower left part of mine is Rabbi Andrew Baker, who is AJC, American Jewish Committee's Director of International Jewish Affairs. In that role, he helped draft and negotiate the adoption of the working definition of anti-Semitism that was referred to earlier and that was first issued by the European Monitoring Center on Racism and Xenophobia in 2005. Since 2009, Rabbi Baker has served as the personal representative of the OSCE Chair in Office on Combating Anti-Semitism. The Organization for Security and Cooperation in Europe is an international governmental organization comprised of 57 countries, including the US. It's headquartered in Vienna, and it has held some of the first international conferences on combating anti-Semitism way back in 2003 and 2004, which have been followed by consensus declarations and commitments by its participating states. As the OSCE's special envoy, Rabbi Baker works closely with European governments and institutions, encouraging and instructing them on measures they can take to combat anti-Semitism, including the use and adoption of the IHRA working definition. Also with us this afternoon in the upper left part of my screen is Rabbi Dr. Marc Goldfeder, who is the director of the National Jewish Advocacy Center. He has served as the founding editor of the Cambridge University Press series on law and Judaism, is a trustee of the Center for Israel Education, and by presidential appointment as a member of the United States Holocaust Memorial Council. Dr. Goldfeder is a former law professor and handles anti-Semitism cases across the country and writes and publishes widely in popular and academic outlets. And last, but certainly not least, in the upper right side of my screen is the Honorable Ken Marcus, who is the founder and chairman of the Louis D. Brandeis Center for Human Rights Under Law and is the author of the definition of anti-Semitism from Oxford University Press. Mr. Marcus also served as the 11th Assistant U.S. Secretary of Education for Civil Rights. So with these three gentlemen, we're going to pose some questions. We're going to be open at the end to questions from those of you listening in. You can simply use the Q&A feature on the lower part of your screen. And we will try to get to questions at the end to the extent that we have time. So Rabbi Baker, I thought I would start with you. Oh, by the way, despite all of their doctors and rabbis and various titles, I've gotten the permission to call them Andy or Andrew, Marc, and Ken. So please don't be alarmed by my informality. They've told me it's okay. So Andy, I guess it would be helpful for me and maybe helpful for our listeners to get a little bit of a history of the definition of the working definition from IHRA. The previous speaker, David Levitt, referred to it as being adopted in 2016, but it has its roots far earlier. So since you were there, maybe you could give us a short summary of its history.
Marc, I'm happy to do so. Look, we were seeing in the early 2000s a surge in anti-Semitic incidents, primarily in Western Europe. And at the time, most governments did not recognize it, did not acknowledge it. And you had Jewish communities growing increasingly fearful, not only because of these specific attacks, but because of the sense that their own governments were unaware or unwilling to label them as being anti-Semitic. This is really where, in effect, the definition originated. There were various efforts to address this problem. I should point out at the same time, you had what has really come to be thought of as the infamous UN Conference on Racism in Durban, South Africa in August of 2001, where you had a revival of the Zionism is Racism canard, where Jewish groups participating were themselves fearing for their own physical safety. Taken all together, it was some time before governments, before international organizations, OSCE prominent among them, realized they needed to really address this new return of anti-Semitism. And in that context, there were, as you noted, international conference for 2000 organized by the OSCE in Vienna, a second in 2004 in Berlin, attended by governments at high levels, including our Secretary of State and many foreign ministers. And in the course of these meetings and discussions, it was natural to lay out what the various forms of anti-Semitism are now being addressed by Jewish communities, and where governments were being called to take into account, to take notice of this. At the time, you had a European Union body, the EUMC, a European Monitoring Center on Racism and Xenophobia. It was founded in 1997. It had never done any kind of analysis of anti-Semitism in Europe, but in 2004, it did precisely that. And what we found in that study was limited information based on data that was collected, opinion surveys. Bear in mind, at the time, very few countries even had the notion of hate crime as a specific form to be recognized and addressed. So governments weren't even acknowledging crimes with a biased motivation, let alone taking it one step further and identifying those that were anti-Semitic in nature. As it were, many of these incidents were reported, and it was as though it didn't take place. When the EUMC did this study, they had, as I noted, limited information from data and from surveys, but interviewed Jewish community leaders. And from those people, they got a sense that there was a very significant increase in anxiety, concern, people literally fearful of being out and about and fully identifying as Jews. One of the factors that played into this this survey work, this report of the UMC, was that while they had monitors in each EU country, over half of them had no definition of anti-Semitism with which to work. More to the point, those that did, there were no two in common. And so that led to, initially with the EUMC, are being asked to help draft a comprehensive definition of anti-Semitism that they could use. This is what ultimately came to be known as the working definition of anti-Semitism. We worked through much of the summer and fall of 2004, and in 2005, it was issued by the EUMC as a working definition. Again, the goal was to define anti-Semitism in ways that would be helpful. We sometimes would speak of this to the policeman on the beat in Berlin or in Manchester. In other words, how to identify what's taking place if it's a demonstration that turns violent, if it's a physical attack, if it's a graffiti on a building, how to characterize it and understand if it's anti-Semitic in nature. Mind you, at the same time, we were recognizing that there was what we often refer to as a new form of anti-Semitism, which was to say anti-Semitism as it related to Israel. We understood Jews were being targeted because in some places they were viewed as sort of surrogates for the state of Israel, attacked by people that had strong animosity toward Israel and found a synagogue or a school bus with Jewish kids a more convenient target. We saw that in rhetoric, in discourse, the state of Israel itself was being demonized. We understood that these too were forms of anti-Semitism. When the OSCE organized its conference in Berlin in 2004, it issued a declaration on combating anti-Semitism, representing the consensus views of what are now 57 participating states. And in that declaration, it indicated that anti-Semitism had taken on new forms and manifestations. This, at least an implicit reference to this anti-Semitism related to Israel. It stated clearly and unequivocally that events in the Middle East, incidents in Israel, can never justify anti-Semitism. And so this was the context in which the definition itself was drafted. What was critical was to offer clear and pragmatic examples that would be useful for people who need to know. As I noted in the first instance, for the police who are first in line to try and identify anti-Semitic incidents, but also for those collecting data, for prosecutors and judges that would ultimately need to act and need to know if what they were viewing was an anti-Semitic crime or an anti-Semitic incident. That was the goal of the definition from the very beginning. I think it is important to point out, I know it was discussed in the previous session here, that in addition to offering these clear examples, two important caveats were also part of that original definition that ultimately was adopted later on by IRA. That was to say explicitly criticism of Israel, at least criticism that is in no way different from criticizing other countries, is not anti-Semitic. And of course, noting that while these are examples, they depend on the context. So use your head when you're looking at this. This is what it was all about. Those those examples, the comprehensive definition, as I said, was issued by the EUMC. I won't go into great detail, but the EUMC was replaced by a different EU agency, the Agency for Fundamental Rights, several years later. It determined that it did not have a mandate to define racism, intolerance, anti-Semitism, or other forms. So effectively, we were speaking of an EUMC definition when the EUMC was no longer existing. Ultimately, I want to say this orphan definition, which nevertheless was gaining more and more use, at least in Europe, but also here in the United States. It was being employed by the State Department for its monitoring work worldwide. Ultimately, this orphan definition found a new home when in 2016 in May in Bucharest, the International Holocaust Remembrance Alliance collectively adopted this definition with very minor edits. And since then, it's been known as the IRA working definition. So I'll stop there, but that's some context and background to how the definition came about, how it has now become the IRA definition.
That's very helpful. Thank you. And I don't know whether we got into it in the prior panel, and folks who are familiar with the definition will know some of the statistics with respect to its subsequent adoption. But Marc, maybe you could give us a little bit of context there, because I know part of your responsibilities have been to travel all around this country and other countries working to have the working definition adopted.
Sure. I believe the current statistic is that since 2016, 867 key states, institutions, NGOs, and universities have adopted the IRA definition for use in various contexts. So it's quite a lot, and it really demonstrates the consensus of the Jewish community around us across every spectrum. You know, again, as Ken Marcus told me when I was talking about this one time, it's important to be precise. IRA should be adopted because it is the correct definition. But part of what gives IRA its strength is that so many people from across the Jewish world can look at it and say that this really reflects their shared lived experience and how they experience anti-Semitism today.
Mhm. So we have this definition, we have its history, and I think it helps us in a context of the human mind and its need to define things. We've heard about how it doesn't illegally chill speech, and that it's being adopted by lots of organizations, governments, et cetera. I guess what I'd like to understand more is, as a practical matter, why does all of this matter? How is this useful in the context of law or in the context of society more generally? Ken, maybe you want to take that one, or at least to start.
Sure, I would be happy to. It matters because too often today, when Jewish people, including Jewish American college students, face hostile environments, the conduct is dismissed as being merely political, especially if there is surrounding discourse that involves criticism of Israel. The notion is that anti-Israel rhetoric is speech regarding matters of public importance. Universities should not take a side. They certainly should not censor, and they should not treat it as being a bias incident. And of course, that is true with respect to actual political discourse. But the IRA definition helps us to understand that in many cases, we're not just talking about political discourse. We are talking about hate and bias incidents that should be treated in a way that is similar to hostility to other groups, even when there are surrounding circumstances that relate to the state of Israel. So we have seen over and over again, case after case, situations in which Jewish students, faculty, and others are subjected to all sorts of abuse, marginalization, stigmatization, et cetera, et cetera. And the initial instinct of university administrators, reporters, and government officials is to say this is just political. The IRA definition helps us to understand that context matters, but oftentimes conduct that is motivated in ways that can be understood by the definition should be interpreted as bias incidents and treated accordingly. The challenge is that too often anti-Semitism is coded, it's disguised, it looks like criticism of Israel. The IRA definition helps us to distinguish between what should be treated as a bias incident and what shouldn't.
Mm-hmm. And what are the legal processes in which you are able to use the IRA definition and have it make a difference?
Well, there are any number of them, but the most common ones involve Title VI of the Civil Rights Act of 1964, which bars certain forms of discrimination on the basis of race, color, or national origin in institutions that receive federal financial assistance, including nearly all colleges and universities. For much of the history of the Department of Education, investigators simply ignored most allegations of anti-Semitism based on a misunderstanding that anti-Semitism could never be anything but a form of religious discrimination. It was only in 2004, during my first stint in government, that we clarified that, in fact, anti-Semitism often has aspects of an ethnic or ancestral discrimination and should be treated as the violation of a federal statute. But even then, the federal government was largely stymied or paralyzed in any case in which there was any connection to the state of Israel in any of the surrounding facts and circumstances. On one of the cases that I heard on appeal when I was the head of OCR, the Office for Civil Rights, we established that in appropriate cases, the Office for Civil Rights should use the IRA working definition of anti-Semitism. But that was an informal determination in a particular case. It was with President Trump's executive order on combating anti-Semitism that this became a policy, not just for that agency, but across the federal government, and one which helps guide investigations of anti-Semitism, or which should guide them. And we hope that it will continue to do so in this and subsequent administrations.
If I could jump in for a second.
Just about to ask you to do that.
Great. Well, a couple of things. First of all, I just wanted to, people may not realize who are watching this, number one, how important it is to have a Brett Baker, someone who was actually there for the writing of the definition. And number two, I was thinking about this, I cannot think of a single other individual who has done more to protect Jewish students in America than Ken Marcus. And there's not even a close second, truly. I mean, and anyone who hasn't read his book on the definition of anti-Semitism, it's the classic, and his work, both in his first and second stints in the government, has done more to protect Jewish students on campus than anyone else has done. So thank you from all of us who do this work. And I want to just sort of expand on that. Title VI is really where it started, but a few years ago, some of us who work in this field were also thinking about what about the rest of anti-Semitism, and especially when it comes to passing state legislation, because the arguments in favor are sometimes equally pressing, because the same thing keeps on happening, right? Because Jewish identity is so multifaceted with aspects of race, religion, nationality, ethnicity. Without having a standard definition for authorities to reference, it's too easy for anti-Semites to hide behind that ambiguity and commit heinous acts with impunity and then claim it was not anti-Semitism. And I'll give you an example of what happens when you don't draw any line in the sand, right? In 2017, a German court decided that the firebombing of a synagogue in Wuppertal, Germany was not anti-Semitic because the criminals claimed it was just the way that they chose to express their anti-Israel politics. And in the end, there was a massive public outcry, which eventually led to Germany adopting the IRA definition. But if you couldn't think it happened here, not one, not two, not three, not four, 5 Chabad houses have been set on fire over the last 2 years. And in each instance, if you go on social media right after, you'll find people claiming it was just an act of mere anti-Zionism, not anti-Semitism. So you need to have a definition that draws some line in the sand. And the practical problem in defining anti-Semitism, as the late great Chief Rabbi Sachs once said, it's a mutating virus, right? Jews are criticized for being whatever a society or a particular part of society hates at that particular moment. The right will call them radicals, the left will say they're fundamentalists. They're simultaneously too liberal and too conservative, too rich and a drain on society. So a definition that can encompass all those possibilities has to be able to cut through the timely rationales given for that timeless hatred, because if you don't, anti-Semites will just find another reason and use that one and that one and that one. If you want to actually protect people practically, you need a definition that focuses not only on the reasons why people hate, but on the actions that are taken by those who are expressing or harboring that hatred, a praxeological, a conduct-based definition. And the one that serves that goal the best, again, is the IRA definition. And it's precisely because the examples that it gives focus on the manifestations of anti-Semitism, meaning what anti-Semites do as opposed to why they do it. Because while anti-Semites around the world give different reasons for their feelings, those feelings tend to manifest themselves in similar repetitive patterns. And in terms of those patterns, again, anti-Semites often look at Jews as a collective, which is why the majority of anti-Semitism in any given era tends to focus on the primary form of collective Jewish identity at that point in history. So throughout the Middle Ages, Jews are for the most part a religious community, and they're hated for their religion, even if the particular Jews being hated aren't very religious. In the 19th and 20th centuries, many Jews became secularized, and the primary unifying collective identity was Jewish ethnicity. So the hatred focused on race, even when the Jews who were being taken to the gas chambers, only had a trace amount of Jewish blood in them. And today, when the primary collective embodiment of Jewish people on the world stage is the people of Israel in their nation state, Jews around the world are hated and held accountable for their country, even if they're not Israeli. And that's why the IRA definition has those helpful examples of discriminatory anti-Zionism that can sometimes cross the line into anti-Semitism. And practically speaking, what these state anti-Semitism bills do is very narrow. All they do is ensure that when you're analyzing the intent behind illegal discriminatory actions, not speech, that target Jewish people, when there's an allegation that the action was motivated by anti-Jewish sentiment, authorities should consider as rebuttable evidence the world's most well-accepted definition of anti-Semitism, and that would be IRA.
So do these generally find their home in hate crime laws, in state hate crime statutes? Is that when you go into a state to try to get this adopted, is that where you're trying to get to, or what?
Well, it's hard to say generally because we've only started really putting it into effect this year. The first three passed into law in the last 3 weeks in Iowa, Tennessee, and Arizona. In Arizona, it was done as part of the hate crime statute. In Iowa, it was done as a standalone throughout all discrimination. So it would also include illegal hiring, firing, and housing decisions. And in Tennessee, it was done as part of their education code, building off Title VI on campus.
Every state is different. South Carolina was initially appropriations. When I started working on the state matters a few years ago, I thought we would develop a model template and then just insert it in the appropriate parts of the state codes. But what we found early on is that state codes actually varied so significantly that you couldn't just find one place to put it in all of the states. Then, of course, you sometimes have legislative sponsors who are members of one committee but not another committee, or various other local considerations.
Mm-hmm. Have you had, either of you or Rabbi Baker, obviously, have you had examples of where you've tried to use the IRA definition thus far, even after adoption, and found yourselves unsuccessful?
Well, we certainly find times where we apply the definition and we determine that we think that a situation is not anti-Semitic, just as we find circumstances where we think that something might be anti-Semitic but not actionable, or where it might be otherwise actionable but might not fall within the statute of limitations. So as with any public interest advocacy, we certainly look at a lot more matters than what we move forward on.
I'll add to that almost definitionally, by taking federal funding, most universities have unofficially adopted IRA because they're agreeing to be bound by the standards of Title VI. What I've found, at least, and I'm sure Ken has probably found the same, is that universities still fight very hard against saying that they're going to adopt IRA. They're willing to take the federal funding, but they don't want to actually apply the standards. And unfortunately, in many instances, they have to wait until there's an actual Title VI complaint waiting to be filed before they're willing to really examine their actions under the appropriate light.
That's a very interesting point that Marc is making. We do hear frequently from administrators that they don't want to adopt the IRA working definition of anti-Semitism, but they have, of course, executed grant assurances to the U.S. Department of Education in which they tell the government that they will comply with the Education Department's laws and regulations, which continue to include guidance incorporating through the executive order the IRA working definition. So they're a little bit like, the person who tells you that they will not speak prose. They say they won't adopt it when in fact they have indirectly adopted it. And even if they hadn't adopted it, the fact is you don't have to adopt the Sherman Act to be bound by federal antitrust law. You don't have to adopt local criminal statutes and ordinances to be bound by them as well.
I think one of the interesting things we have seen over the years in Europe, and as Marc has cited the one incident in Wuppertal, there clearly have been others where we're talking about physical attacks, even deaths of Jews in incidents that certainly should be understood as anti-Semitic, but where governments did not do so. That, of course, is where the definition is a useful tool, an essential one, you might say. And I think one of the really interesting evolutions is how significant the definition has become throughout Europe today. Frankly, when when the US stepped forward back in 2004 with legislation to create an office at the State Department, a monitor, when it demanded a comprehensive worldwide report on anti-Semitism, we tended to see this as a problem across the ocean, really not one that we were experiencing significantly or directly here in the United States. And we were looking for tools to push Europeans to recognize and do more. And in fact, over the years, they've stepped up so that even countries, and here so much of the debate about the definition becomes, well, it's intended, we hear, to stifle criticism of Israel. I want to say in European countries where criticism of Israel may even be baked into their political leadership, take a country like Sweden, which even recognizes politically the state of Palestine, it has adopted and endorses the IRA definition. Now it is something that is being promoted by the European Council itself for all European Union members to take on and use. It has been effectively endorsed by the Council of Europe and its Commission on Racism and Intolerance. We came very close in the OSCE, which unfortunately operates or reaches decisions by consensus for an OSCE adoption of this. Effectively, all but one of the 57 participating states prepared to do so. All of this came about in the last, really, I want to say half dozen years. And it's come about because we have seen literal physical attacks on Jewish targets that have been not recognized by law enforcement and the judiciary in these countries. And that definition is useful. It starts even as an educational tool for police and prosecutors in the very work that they're learning how to do. And in some ways now we've had to see here in the United States what was being useful, frankly, to confront problems in Europe is also needed here as we see the problem of anti-Semitism itself in America, increasing in ways that, frankly, back in 2004, when this legislation was first adopted, creating our US Special Envoy, we did not see, we did not perceive as a domestic problem.
I will tell you also, I mean, there are a lot of people who spend a long time pretending that anti-Zionism is unrelated to anti-Semitism and fighting against IRA. And last May, a lot of their arguments really fell. Right? Last May, when Israel was fighting back against the terrorist attacks of Hamas, anti-Semitic attacks across the country shot up over 400%. And in cities around the world, but even in this country, including Los Angeles, Utah, New York, Florida, Michigan, Arizona, DC, Illinois, hundreds of synagogues and Jewish community centers and kosher restaurants and Jewish businesses and individual Jewish people were targeted and attacked and threatened and chased, all because they were Jewish. And in each of those instances, that thin veneer of anti-Zionism was pretty clearly shattered by the open expressions of enraged anti-Semitism. And, you know, on social media platforms, for example, in 1 week that last year, the phrase Hitler was right was tweeted over 17,000 times. And so when you have, Hasidic Jews who aren't necessarily fans of the state of Israel being attacked on the street as proxies for that state, it gets harder and harder to claim that anti-Zionism is not anti-Semitism, and it gets harder and harder to say we don't need a definition, again, that draws some lines in the sand. And sometimes physical attacks really do make that difference in bringing it to people's attention.
Mm-hmm. Mm-hmm. So in the first presentation today, my friend David Levitt was talking about a new paradigm or involving what he termed a rebuttable presumption, that if something falls within the definition, the IRA working definition, that it is, whether it's prima facie or a rebuttable presumption that it's anti-Semitic. Is that something that I've certainly, you've all thought about that. Is that something that you support? Are there downsides to that he didn't talk about that we ought to think about?
I've used that term myself in my writing, and also used the McDonnell Douglas standard as a comparison. Look, if you're too literal about the working definition, it's not going to work. And in fact, the terms of the definition indicate that one should take into account the overall circumstances. If double standards, regardless of context, were an indicator of anti-Semitism, then a rabbi friend of mine would certainly be anti-Semitic, because he believes that every community should hold themselves to a higher standard than they hold others to, and the world would be more peaceful if we did. And so, yes, he holds Israel and the Jewish community and to a higher standard. So there's a rebuttable standard. I think there should be. One should look at context. But if there isn't a reason to justify the use of different standards, then yes, the burden shifts, and one gets to the point where one has to determine that something other than political disagreements are at hand.
Yeah, I agree with everything that Ken said. Context is crucial here, as it is in all instances of alleged discrimination. For example, in the context of employment discrimination, the Supreme Court famously said that the objective severity of harassment should be judged from the perspective of a reasonable person in the plaintiff's position, considering, and I quote, all the circumstances, right? Every inquiry requires careful consideration of the context in which the particular behavior occurs and how it's experienced by its target. Anti-Semitism is no different in that sense than racism or sexism, in that no two cases are ever exactly the same, which is why those caveats in IRA are so important. But again, if there's an action that was taken that seems to that targets Jewish people and seems to be motivated by intent, then I think it is absolutely fair that there's a rebuttable presumption that the gold standard definition of anti-Semitism should be used to determine whether that was actually the motivation.
Mm-hmm. And I've listened to presentations, read articles, particularly in the academic world, where there seems to be a greater fear that putting this definition in the hands of whether it's deans or university administrators is potentially more damaging, more harmful. I don't quite understand it, but maybe you guys have heard that and can explain it to me.
I'm guessing that Marc just turned towards me, so I'll start. I will say that I believe that with the IRA working definition of anti-Semitism incorporated into federal policy, there is indeed a danger that it will be misused or overused, and that speech will be violated either by federal officials or by school administrators. Not because it's the IRA definition, but because it's a civil rights provision, and any civil rights provision, any legal provision can be misused, can be overused, underused, what have you. I don't know that there is a civil rights statute that hasn't been misused in some way. You could write books, and there are books about the ways in which various fundamentally important civil rights statutes have been used to suppress speech or otherwise create problems. That doesn't mean that we should rescind them all. It means that we should use them with care. And I think that people have heard today, including from the last discussion, lots of different guide rails that are put in place to make sure that this particular provision is not misused. And so I think that the threat is less with this provision than with most. Moreover, in the context of American college campuses today, that really isn't the risk that I see. There are other forms of discrimination in which there may be a tendency for administrations to jump a little bit too quickly to take what might be a politically popular position on their campus. But there are a few situations in which taking an aggressive position on anti-Semitism is the politically popular one. So I haven't really seen an unusually great risk of over enforcement by university administrators. What I have seen is a significant risk of under-enforcement. And in fact, we see it on a very regular basis, certainly a weekly, if not a daily basis, situations in which university administrators do not enforce the rules as forcefully with respect to anti-Semitism as they do for other forms of bias. So I'm not going to say that there's no risk at all. For any effective law enforcement tool, there's a risk of misuse, but I think that the risk is significantly less in this context than in others.
I'll just add, if I can, which is that the argument that the IRA definition could theoretically be misused is completely valid, but I think also ultimately misleading, because the correct conclusion to be drawn from the concerns people express is that any policy using the IRA definition should be crafted carefully to avoid censoring speech, not that it shouldn't be used in a policy about discriminatory harassment. And the second level you sometimes see is that people say, well, it will be hard for us to distinguish anti-Semitic acts, which can be regulated, from anti-Semitic speech, which can't. I hate to say it, but that argument to me is kind of anti-Semitic because, for example, the executive order doesn't create any new gray areas of speech act distinctions. It uses the same longstanding definitions of harassing conduct in all Title VI and Title IX cases. If you can tell the difference between racist speech and racist acts, or sexist speech and sexist acts, but when it comes to anti-Semitism, it's all just too blurry, you might be an anti-Semite.
Got it. Andy, I'm curious, if you had it to do over again, are there changes to the definition that you'd like to see? Do you look at it and say, oh, I wish we could do X or Y? To either make it more forceful or eliminate or diffuse some of the criticism?
Well, I have to say, first, when we started, there were other definitions being used that had more, maybe they were more eloquently phrased. Natan Sharansky had his 3 Ds, which was an easy way to remember some of these things. My friend, one of the leaders in a lot of these efforts, Irwin Cutler, who's a former Attorney General of Canada, but now also the Canadian Special Envoy on combating anti-Semitism, said the way to understand this form, these problems today, Israel has become the Jew among the nations. So if you understood in traditional terms what the Jew was when speaking of anti-Semitism, so Israel today has filled that. I think when we were involved in drafting this definition, and the first challenge was to reach a consensus on the part of primarily Jewish academics and experts who were part of all of these drafting efforts in Israel, in Europe, and in the US, to come to something where first we all could agree that this was a useful definition, and I would emphasize useful. The whole goal was for someone to be able to take it and use it. So it may not have been as eloquent as some or as catchy as some, but I think we felt it did what was needed. And as we noted before, and as it's still being referred to as a working definition, initially when it was issued, and it was issued at the time by the director of the EUMC, who could do it in her own right, if it had more initial permanence, that might have entailed adoption by all of her governing board, which included all of the then EU member states, which would immediately make it a politically challenging process. So it was issued as a working definition, effectively to say, let us know how it works to the different communities that would make use of it, governments that would make use of it. And in principle, it was open to being redrafted or changed depending on its practical use. So I think, in fact, it has really become more, in a way, more permanent than we had imagined it would be at the time. But I think that permanence has largely been the result of it being used and appreciated effectively. It works in so many of these countries that have taken it on, that have adopted it, that are using it for education and training, so that I want to say even the critics of this definition, as we saw, for example, in the debate around the time when Jeremy Corbyn led the Labour Party in the UK, and significant accusations of anti-Semitism within that circle, even critics would refer to this as the authoritative definition, if only to go on and then criticize it. So I think in that sense, it's really lived up and maybe even gone beyond what we hoped it would be at the time. Again, it's a working definition. Perhaps it can be open to change. It's already been stated here how anti-Semitism mutates over time. There may yet be new forms of it that we'll have to address. But I think up till now, it's served its purpose and then some.
Mm-hmm. Marc, when you go to, as part of your new effort into various states, are there parts of the definition that you see that you wish were slightly different? Either something that you wish were there that isn't, or something that is you wish weren't?
No, not really.
No.
I think that at least for the time that we're living in, it does a really excellent job of capturing the modern manifestations of anti-Semitism. If and when anti-Semitism mutates, I'm sure that the definition will update accordingly.
Mm-hmm. Ken, have you had the same experience as you look at cases to litigate and bring?
As I look to cases to litigate, I have, but when I looked at the definition as an academic a number of years ago, I had a different position and could possibly even be described as a critic of the definition, in the sense that I offered criticisms. I provided various ways in which I thought that it was imperfectly drafted, especially with respect to the preface, which says that anti-Semitism is a certain perception, when in my mind it is uncertain in various respects that I explained. So I came up with my own definition, as many people have, and I put it aside because while I have my own definition, and lots of scholars do, there's immense value in having a common definition. And even if the definition is not perfect, it's very, very good. And for practical purposes, it's excellent. A number of years ago, my friend, Professor Dina Parat, tells a story that she gathered a number of academics from around the world to discuss the definition, the working definition. And she asked them all, do you think it's perfect, or do you think that you can improve on it? And every one of them, being self-respecting scholars, came up with some respect in which they thought they could do better. But each of them had a different way in which they could improve it, and none of them agreed with anybody else. And so when she asked, okay, so should we recommend that it be changed? They all said no. No, leave it as it is. While each of us might have a different way we would do it, it is a very good definition. It is a definition which even then had garnered a certain amount of support and credibility, so they thought they should stick with it. Even more so today, years later, when a remarkable number of institutions have now gathered behind it. I think the definition, although no more perfect than anything else created by human beings, it's an excellent definition. It's the best available definition, and there is immense value in using a standard definition.
Ken, I'm going to turn back to you for a moment. We have people from, I believe, all over the country listening, but I think we have more folks from Illinois probably than anywhere else, particularly since we're offering CLE credit in Illinois for this symposium. Could you tell us a little bit about the action that the Brandeis Center and others brought with respect to the University of Illinois in Champaign?
Sure. The Brandeis Center is continually monitoring the country for situations in which Jewish students and faculty face discrimination, and where we find a problem, we try to work with administrators. But where this is insufficient, we will sometimes hold them accountable with law. At the University of Illinois, I had been having discussions with local Jewish community members for years about the problems there, and there were numerous efforts to deal with just a host of dozens and dozens of problems facing Jewish students, including vandalism, but also other acts over a period of years. And at a certain point, when local Jewish community members and students told us they'd had enough, the Brandeis Center filed a complaint. I credit my colleague Elisa Lewin, who spearheaded the effort during my time in government. She was the one who prepared it together with our outside counsel and working with Hillel International and the local federation. That case remains pending. Today, it led to an investigation which the Department of Education's Office for Civil Rights has opened and which is pending. But as an interim matter, we entered into an agreement with Chancellor Jones of the University of Illinois, under which he made, I think, some rather important statements. To begin with, he acknowledged that for many students, Zionism is an integral part of their Jewish identity and needs to be recognized in the same way as we recognize the identities of other groups. He also made a commitment to establish a task force and to take other initial steps to deal with anti-Semitism. And we applauded him for those initial steps. He did not expect us to drop our claims because he, I think, recognized that the steps that the university was willing to take at that time were not sufficient for us to withdraw the case. But they have made those initial steps. We continue to be in discussions with the university, and the investigation is still pending. Sadly, we continually receive reports from the university. Some of them are positive about good things the university is doing or saying, but many of them are quite negative. And so when those happen, we are pushing the university to respond. Sometimes they do in a way that we think is favorable, and sometimes we think that they should do more. But that complaint remains pending to this day, and we continue to advance it.
I guess I must have said the secret word when I mentioned CLE, because now all of a sudden I've seen folks popping up with questions about other states. So I'm sure that Steve Resnicoff will cover this, but the short answer is DePaul is only a provider of CLE credit in Illinois, but that doesn't preclude folks as participants from utilizing the materials to make, I believe you go to the CLE board in the various other states in which you may be licensed and applying for credit there. But I'm sure that there's more that Steve can offer about what that process is. But we can't award it outside of Illinois. Marc, let me come back to you for a moment. Where do you see the definition and its adoption going from here? Are you on an organized mission to head to all 50 states, or are you, where are you heading? Where are you taking it from here?
Well, since it passed in Iowa just less than a month ago, 13 other states have actually asked for state-specific drafts. And so working with those states, currently it's already pending in the state of New Jersey. And I will tell you that I have a meeting set up in DC, hopefully in the next few weeks, with senators' offices about, people are aware, but the Anti-Semitism Awareness Act originally in 2016 and 2019, which passed the Senate and stalled in the House, about trying to restart that process using this new model bill.
So you're going to be on the road a bit.
A little bit, yeah.
I think at this point, Steve, maybe we should think about entertaining some questions from the audience. I know that I have seen a number come across my screen as I've been watching.
Yes, thank you very much, Mark. Let me just mention first the proviso that I gave in part 1 is that the fact that I ask a question doesn't mean it's my question, doesn't mean that I agree with the question, doesn't mean that I don't agree that you already answered it, but I'm going to try my best to impart it. But first, as to the CLE, you're right on the money that we're not authorized to offer CLE other than in Illinois. In the past, some people have told me that they have taken a letter from us saying that they attended and they've had some success with some states that would offer them a credit or give them credit, but I have no specific details on any particular state. First question I wanted to ask, one person asked a question and I'm really not going to ask you for the answer. I'm going to ask you for a response, but after the program, and that is, he asked if you could please tell everybody how they can help you. You know, what can they do other than obviously making financial contributions, I guess? What can they do to help you with your work? And if everyone here would provide that information to me, I will be able to send it out to all the people registered, even the people that had a difficulty actually logging in, so they weren't here. But so I'll be happy to give that information on. For the first real question, I wanted to ask basically a question. Someone wrote a question that said, what about, if you think about the Clery Act, the federal act, the Clery Act, which requires universities to report incidences of certain types of hate crimes. We mentioned this at the outset, that hate crimes are quite a smaller subset from anti-Semitic incidents. Anti-Semitic incidents covers much more ground. But he said that with respect to the Clery Act, there is required mandated education for people. I myself, I believe, have filled out as a requirement at DePaul educational programming to make sure that I'm aware of what the Clery Act requires. What about moving for legislation that would require monitoring and reporting by universities of anti-Semitic events, not just hate crimes, and require administration to actually be educated about IRA, since after all, as was pointed out, they're already certifying that they are taking the IRA definition into consideration. So let's improve it by providing education about IRA to its faculty and staff. What do you think?
I think that's an excellent point. In theory, they're already supposed to be reporting these, but I'll tell you, in 2017, for example, there was a swastika that was drawn on a bathroom stall in Binghamton University, and the school called it a hate crime, but they said, well, it wasn't enough evidence to say that it was motivated by anti-Semitic bias. You'd think a swastika would be the line, but
we should know, Mark, just to mention, if you don't mind me stepping in,
yeah.
In 2020, the government revised its regulations or information as to the Clery Act. Up until then, they had a 300-page book giving advice. And one of the examples that they said was not necessarily a hate crime was using a swastika on property. That's one of the things that they said was not necessarily a swastika. So which leads to the second question. And that is, you talked about David Levitt's recommendation that there be a rebuttable presumption. It would seem that some of the examples in IRA would be more suited for raising a rebuttable presumption, such as a swastika, and others might not be as suitable for a rebuttable presumption. For example, someone who is Palestinian may have a personal interest in what goes on in Israel, and this double standard that he applies to Israel may be just representative of the fact he doesn't care about the other place, but he cares about this one. So, I mean, it might not necessarily be deserving of a rebuttable presumption. Do you think that that all the examples or particular examples should actually be given the status of a rebuttable presumption? Rebuttable means it can be rebutted, but that it should at least push the burden onto the other side.
Yeah, so again, I mean, if we're talking about in terms of enforcement, I think there's
Yes.
already, we're talking about a case, there's already been an action that was illegally discriminatory, whether it was a hate crime or it was illegal hiring or firing or housing or something on campus that was so severe and pervasive that a Jewish student was unable to partake in a campus environment. And it was directed at a Jewish person, and there's an allegation that it was based on anti-Semitic intent. I think it's fair for there to be a rebuttable presumption, and it can be rebutted. So in the context that you gave, if he says, I'm not anti-Semitic, I'm doing this because of a certain thing that happened to my family, whatever it might be, that's how you rebut that presumption. But given all the context that had to have happened before you're using IRA in an enforcement context, I think it's absolutely fair to have a rebuttable presumption.
Okay, another question was asked was, do you think there's a role for campus codes of conduct which ban harassment and discrimination based upon ethnicity or race as a way to discipline students and faculty on college campuses who create a hostile learning environment for Jewish students and faculty? Is for any of the panelists who wish to.
There frequently are. It is not unusual. It is quite commonplace for universities to have students that indicate a prohibition on harassing others based on race, color, national origin, religion, and various other criteria. We review these policies on a regular basis. It is seldom that we see a policy that doesn't include those categories. Now, it would be nice to see greater clarity and specificity. It would be nice to see an acknowledgement that this includes ethnicity or ancestry as part of race and national origin. It would also be nice to see a recognition of the way in which the executive order incorporates the IRA definition. But generally speaking, most universities do have such policies. They just aren't clear or specific enough, and they aren't well enough enforced.
Another question is, we often review incidents of anti-Semitism in reference to Israel or to Zionism. How is this analyzed as to religious specific actions, for example, circumcision or shechita, ritual slaughter, targeted as humanitarian issues?
If I could jump into that one, because increasingly this has become a focus for some of our work in Europe. More and more countries are, in fact, banning religious slaughter, and a number of countries have at least entertained legislation that would limit or prevent non-medical circumcision, brit milah, essentially. In this case, I think it's fair to sometimes say something may not be anti-Semitic by intent, but nevertheless, it is anti-Semitic in effect. If Jewish communities can't have brit milah, their future is surely called into question. The difficulty or growing cost of getting kosher meat, and ultimately perhaps the ability to get it all together, will severely impact Jewish life. Most of the more recent legislation comes from animal rights activists. There are some countries, Switzerland is one of them, that banned kosher slaughter over a century ago, not out of a concern for pain to animals, but as a way of keeping Jews out of coming to Switzerland. So it is certainly connected. What we often see, because these are practices such as circumcision, which are largely uncommon in Europe, that anti-Semitism becomes part of the public debate when these proposals are being advanced. And certainly much of this has been bolstered by populist, anti-immigrant, particularly anti-Muslim parties and movements. So the environment has become a more and more intolerant and toxic one in which these efforts are undertaken. And as we saw last year in Luxembourg, when the Belgian Jewish community sought a legal decision that would allow for religious slaughter, the court did not mandate that governments need to do that. So we're further now challenged with ways to protect these longstanding religious practices that are going to go, or that will have to, by necessity, go outside the courts themselves.
If I could just jump in for a second, I agree with everything that Rabbi Baker said. One of the other things, I think, if you look at some of the very specific, I'll take for an example, the European Court of Justice in 2020 ruled that authorities in European countries could ban the practice of ritual slaughter. If you take a look at some of the nitty-gritty of those opinions, I do think there's an element of anti-Semitism, and we can just look at the double standards applied. So, for example, in that ruling, there was an allegation of discrimination, and the court said, yeah, there's no similar provision. They required prior stunning before killing animals for kosher slaughter. And they said, yeah, you don't have to do that when you're hunting or recreational fishing or during cultural events or sporting events, but you do have to for kosher, because otherwise, they said, hunting and recreational fishing will be rendered meaningless. And they didn't care about rendering meaningless kosher slaughter, but they did care about rendering meaningless hunting and recreational fishing. And when they said that's not okay, the court said, and this was unbelievable hubris, they said, from our perspective, we think you'll be all right from your religious rights the way that we read them if you have a stunning requirement. They didn't care that both Jews and Muslims said, no, that doesn't work that way. They were totally fine rendering their religious freedoms meaningless and keeping hunting intact. So I think sometimes you do catch elements of discriminatory double standards, even within the nitty-gritty of those opinions.
One person asked whether or not BDS violates or falls is anti-Semitic under the IRA definition. He didn't say whether an individual might be anti-Semitic and another individual might not be, but the question was whether BDS violates IRA. How would you like to respond? Does anybody want to respond? Rabbi Baker, how about you?
Sure. Look, you have, even within the state of Israel, Jewish groups who will say, I'm not going to buy wine that comes from across the Green Line, that comes from settlements. It may be a form of a boycott. I would not ascribe that to be anti-Semitic. On the other hand, there are those who are proponents of BDS and understanding its origins that extend this across any border. The goal, the effect is to say all products of Israel should be boycotted. All contacts with the state of Israel should cease, and effectively view it as a vehicle for undermining the very existence of the state of Israel. I think it comes back again to depending on the context. So I can see that in some places, in some ways, one would have to argue, yes, the IRA definition would label this as anti-Semitic, but conversely, in other settings, I believe it would not.
Steve, if I could just jump in for 1 second. We're very pleased to have Ken Marcus join us today. But Ken, being as popular as he is, has another commitment coming in on Zoom in just a few minutes, so he's going to have to drop off. So I at least wanted to take this opportunity to thank him for his participation and his wisdom, and wish you all the best in your endeavors going forward.
Thank you. It's been a pleasure. It's been an honor. Steve Resnicoff, thanks for putting this all together. Great being with this panel. Thank you.
Thank you so much, Ken. So I actually, there's one other question, but it was specifically for Brandeis Center, so I'll ask a different question.
Oops,
the last question,
sorry.
maybe no, I understood you had to leave. The last question, and it is like this. It came out of the first session, but I think it's relevant to this session as well. The Jerusalem Declaration, we know relatively a lot about the long, extensive vetting process involved in creating the IRA definition, how it was a consensus position, and a lot of people went into it. A lot of work went into it. We don't know, at least I don't know, and the questioner doesn't really know, much about what went into the Jerusalem Declaration. They say they describe themselves, or the declaration describes themselves as certain types of experts. Doesn't mention any experts, as far as I read it, in law, which might, and I think that it is telling to some of the criticisms that David Levitt had in the first session regarding the Jerusalem Declaration. But Rabbi Baker, do you or Mr. Goldfeder, I don't know, Professor Goldfeder, I know you're an adjunct, so but do you know anything about how many people really were involved with the Jerusalem Declaration? Because I had heard rumors that, and I don't know if they're accurate, that it was really primarily drafted by a couple of people, and then the other people signed on at the end. Do you have any idea what the process was like?
Well, I think it began with a relative small group that was primarily focused on the areas in the IRA definition that spoke of anti-Semitism related to Israel, that wanted primarily to make the argument that most of those examples shouldn't be considered anti-Semitic. And with the draft in hand, it sought the endorsement of others. Clearly, there were those who signed on who, on reflection or when being contacted, sought to have their names removed. So they certainly weren't part of an overall drafting process. Probably if you were to direct your question to the signatories themselves, they would be able to tell you more. Although what I think is important to see is that while it purported to be a definition that would replace the IRA definition or improve on it, however you might put it, at least when it first was promoted, I don't think any of that has happened. I mean, it sits there, but ultimately, certainly, Marc knows better here in the United States. I can see in Europe, the IRA definition has become more and more the authoritative consensus definition. And as that others, including Ken, has said, this is what matters, a definition that pretty much everyone can accept and then use collectively.
Yeah, I mean, the other definitions, particularly JDA and Nexus, didn't solve any of the problems that people had with IRA. And if you look in the anti-Semitic papers that came out the next day in articles, they had the exact same criticisms. You're never going to go far enough. IRA doesn't actually do anything to minimize Palestinian rights. And so if you start with the notion that, well, it does and I'll fix it, you're never going to get anywhere. I like to tell people is that it will be much more helpful if people were concerned, the JDA and Nexus groups, about IRA's misuse. They should direct their energy to make sure that it's applied properly, rather than offering, these unnecessary adjustments anti-Semites will only use to dangerously undermine what's a near universal understanding that's finally raising awareness of the problem's many manifestations.
So I want to thank you, Marc, for chairing this panel, and thank all the panelists for their wonderful contribution.